Today, we're busting some myths on the United Nations Declaration on the Rights of Indigenous Peoples. On December 3, 2020, the government fulfilled an election promise and introduced legislation to implement the United Nations Declaration on the Rights of Indigenous People. This is an important milestone because the Truth and Reconciliation called the Declaration a framework for reconciliation. Legislative implementation of the UN Declaration through Bill C-15 will move Canada from noble words of apology and aspiration to active reconciliation and full honoring of Indigenous rights in law. In 2016, the CRC in Canada affirmed the UN Declaration with these words: "We honor the Declaration's expression of Indigenous perspectives on justice and right relations that have too often been missing and ignored in the shaping of our collective lives." However, the Declaration still receives opposition, and some of this is due to misunderstandings and misconceptions of what the Declaration does. Let's tackle a few today. Many people believe the UN Declaration is merely aspirational and there's no current obligation for governments in Canada to actually implement it. This is simply false. The UN General Assembly adopted the UN Declaration on the Rights of Indigenous People in 2007 as minimum standards for all states. The intent that all states should live up to these standards has been repeatedly reaffirmed through subsequent UN General Assembly resolutions. The Declaration is now a consensus international human rights instrument unopposed by any state. In fact, the Declaration already has legal effect in Canada. Canadian courts have established that declarations and other sources of international human rights law are relevant and persuasive sources for interpretation of human rights in Canada's Constitution. Another myth Canadians have about the Declaration is that the UN Declaration leads to Indigenous people having rights that other people don't. The Declaration is based on universal principles such as the right of self-determination and the right to live free from discrimination, rights guaranteed to all peoples and all individuals respectively. However, like other international human rights instruments, the UN Declaration interprets and applies these rights to a specific context. In this case, the distinct needs of Indigenous people resulting from the long history of colonialism, dispossession, marginalization, and impoverishment. The Declaration also requires states to uphold the commitments they have made to Indigenous peoples through treaties and other agreements. Many are also concerned that the UN Declaration's provisions on free, prior, and informed consent would create an absolute veto over resource development projects. The Declaration never uses the word veto. It is not credible to claim that the Declaration's provisions on free, prior, and informed consent, FPIC, are absolute. The FPIC provisions are also not arbitrary. They are necessary to protect and uphold fundamental legal rights. FPIC is also intended to provide a rigorous safeguard against state decision-making processes that ignore the consequences for the health, well-being, and cultural integrity of Indigenous nations, communities, families, and individuals. The necessity for such provisions should not be controversial in Canada given the public acknowledgement of the tragic harms that have been repeatedly inflicted on Indigenous peoples through decisions imposed against their wishes. Respect for FPIC puts Indigenous peoples in a more equitable position when their representatives come to the table with government or industry. A commitment to move forward on the basis of mutual respect and agreement promotes reconciliation rather than conflict. FPIC also provides government, business, and Indigenous peoples with the certainty that they seek for long-term planning. Our final myth today says that implementation of the UN Declaration would undermine existing rights of Indigenous peoples in Canada, including treaty rights. International human rights standards are created to raise the bar for human rights, not to lower it. States should always uphold the highest applicable standards. The Declaration explicitly states that Indigenous peoples have the right to recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors to have states honor and respect such treaties, agreements, and other constructive arrangements. Thank you for watching. We hope you'll join us in advocating for Bill C-15. Thank you to the Coalition for the Human Rights of Indigenous People for allowing us to use their fact sheet implementing the UN Declaration on the Rights of Indigenous Peoples, Myths and Misrepresentations.